Gentlemen, here we go. We are on the record here for oral argument in cause number CV 210432, Arizona Biltmore versus the Conlon Group et al. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument and make sure you're speaking into the microphones. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal should you choose. We have read the case briefs, we have discussed the case, are familiar with the facts and your arguments. Bear that in mind during your presentation. At this point, are you ready to proceed?
As ready as I'll ever be. Thank you, Your Honor.
Please do so.
May it please the Court, my name is David Abney. I'm here representing the appellants. Today is the 27th day, I believe, of the invasion of Ukraine by Russia, and it makes me appreciate even more democracy and the rule of law, the opportunity to come here and to try to resolve our differences in a calm, rational, and fair way. And with that intro, to calm me down, this court remanded for a recalculation of damages and identified what the recalculation was supposed to be. It was to be for the deduction from total damages from the legal fees, those fees that were incurred over the North Spaces aspect of the litigation. But when it got back down to the Superior Court judge instead shifted the explanation for the $350,000 figure it had already provided in the original calculations. Originally in 2018, the court had said that it was an estimate of what the association was in fact prepared to spend for the full case, the Northern Spaces and the Southern Spaces part. And then on remand in April 2020, the Superior Court said, no, what the $350,000 now is an estimate of what the association spent only on the North Spaces part of the case. A recalculation for...
Counsel, let me stop you though. I understand completely what you're saying, but the court actually kind of cut you a break. If it had strictly followed the remand and a portion between that $350 for the North and South Spaces, it could have actually increased the damages to your client.
Perhaps yes, perhaps no. We don't know because there was no recalculation.
At least the court, as it explained it, said this was a benefit to your client because I lumped them all together, and if I had portioned out, it would have reduced this $350 amount.
It might have, but we don't know. And you can't...
Well, I mean, the court said it.
Well, that's what the court said, but the court, there again, the court was simply making an estimate of what it thought was going to happen or would happen. But what it was actually supposed to do was to take a look at what the fees were that were actually incurred. And there's only two ways to do that. You either go from the billing records that are prepared at the time, the contemporaneous ones that most law firms prepare, or you reconstruct them, and occasionally you have to do that.
That's true for cases in awarding attorney's fees, but this is not an attorney's fees case. This is a damages case, and it's clear that the amount of fees incurred, regardless of how they were billed, are the damages.
Well, I don't know, we may have gotten a tomato-tomato discussion on this point because we're talking about legal fees. That's the whole point here. What are these legal fees that were incurred for North Spaces?
This isn't a award of legal fees. This is the association incurred this much damages.
Right.
And they paid this much out in fees.
Correct.
Okay.
But to establish what the fees are, you actually do a sort of you have to use some of the principles from cases like China Doll or, well, how else do you figure out what the fees are? You identify the attorney, the paralegal, the clerk, whoever that did the work. You identify the hourly rate, you identify the number of hours, and you identify the task. And then at the end of all that identification, you calculate up what the total fee is. That's how you do it. And it's mentioned in China Doll, but that's just common sense, isn't it?
Well, because I thought that determining the amount of damages can be a lot more general or a lot less exact than it can in a normal fee request.
I don't think so. I think the less exactitude from Arizona law comes in when you're talking about just general kind of damages. But here we're being very specific at what the trial judge was supposed to do, recalculate the legal fees that were incurred. And there's only two ways you can do that. You can guess, and People guess all the time, and that's what the court did. It guessed, but it wasn't supposed to guess. It was supposed to make a recalculation of the incurred fees.
Well, but as I read the record, and I'm a lawyer, I don't do math. Judge Broadman, who probably is better at math than I am, had an analysis of why the amount of fees was probably lower than $350, but that's the number that he was going to use under his analysis, and given that damages are more general than an attorney's fees request would be. Why doesn't that work?
It's not really an analysis of what's been incurred. It's like the view of the solar system, if I may go back. Ptolemy, the Greek astronomer, had this beautiful system for the solar system. It had the sun in the middle, the planets, everything, Earth in the middle, all the planets, the sun, everybody resolving. It worked perfectly. You could predict every astronomical event based on the Ptolemaic system, and it was 100% wrong. It wasn't until Copernicus and his friends came along that everything got revised and we understood what reality was. Here, the judge is following a Ptolemaic system. He's trying to make everything fit into the figures he already had. And the main way he did that was simply to relabel the $350,000, which was originally labeled as a figure for north and southern spaces. And then all of a sudden, after the relabeling in 2020, it became a figure solely for north spaces. That's not an analysis.
I don't think that's accurate, Mr. Abney. Yes, it was for both, but he was only required to deduct the northern. So that's why I keep getting hung up on. I don't see how your client could be prejudiced by whatever error it is you've identified, because before we had $350,000 being deducted. The record says that was for both amounts. But he wasn't required to deduct the southern spaces.
Well, that was the conclusion that he had reached for both amounts. But then again, the conclusion wasn't based on any records that were devoted to the northern spaces. So we simply don't know, and we can't know until somebody does the work.
Well, but the work was done, because that $312,000 was actually the assessment that was sent out for it. The total bill was $350,000, and what you're faulting for, at least what I hear you're faulting him for, and correct me if I'm wrong, is not saying of that $350,000, $270,000 or $295,000 or some number is south spaces and some number is north spaces. But didn't he give you the benefit of the doubt by saying, even though it could be smaller, I'm going to give you the entirety, the full $350,000?
We don't know what benefit he gave anybody, because he didn't actually do a calculation based on the records. Now, there were voluminous records about attorneys and paralegals doing this, that, and the other, but they simply did not break out what was for northern and what was for southern. So we don't know, bigger, lower, same, we have no clue. And nobody can have a clue.
Is there anything in the record that you can point to, or any suggestion that it should have been bigger than $350,000?
I don't know. No. And I couldn't say it should be lower than $350,000. I can't say that it should be $350,000. We don't know, because nobody did the breakout. And until you do a breakout, and it's probably going to have to be on reconstructed records, nobody's going to know how much was northern, how much was southern. There's just no way to tell.
The parties didn't want to do that, by my reading of the record. They didn't want to provide the information that you now say is essential.
Well, that's an interesting point. I'm not quite sure on exactly your preface to the question, but it made it sound like my clients didn't want to do it. And that's what their brief said. My clients didn't want to do it. My clients can't do it. They don't have the records. They have their billing records. We don't have them. And they didn't want to come forward and produce the original but contemporaneous records that would show the northern spaces allocation. They may not exist. And where they didn't want to go and reconstruct them, which, as a lawyer, I don't know if you've ever had to do it, but I've had to go back occasionally and reconstruct what did I do on that day for this particular case, and I know it's happened before in other fee requests. You have to go back and reconstruct it. You only got two choices here. You go with the original records that have the breakout, if they exist, or you reconstruct the records. You can't just say, well, let's take a guess. That's not trying to figure out what was incurred. If I may take a short break here, I don't want this to be overlooked because I did bother to read the Sibley versus Jeffries case. And I didn't know in the 1940s you could just go on the government land and start raising hogs and sheep and cutting trees and raising crops. But I think that's not the point of the case that you wanted me to get, the historical point. Law of the case, I think, is a flexible doctrine, and things can change. I'm not quite sure why you wanted me to read the case, but if it's for the principle that law of the case can change, yes.
I'll tip my hand for you if you were playing poker. I think that what the court did on remand, and I'm not speaking for the entire panel, but I think what the court did on remand violated the instructions on remand. I was part of the prior panel, and we said you didn't deduct the North Spaces fees. Do it. On remand, the court, I think very adequately, and this is where I depart from you, said, appeals court, you were wrong. I did deduct it. Here's why or how I arrived at that calculation. Here's, when you look at the total pot of damages, all the stuff we've been talking about now. So that's where I'm stuck, is when we have a situation in which the Court of Appeals got it wrong, arguably, what is the trial court supposed to do? And what Sibley says, as I read it, is that they're supposed to follow our rulings, and that certainly seems to be the rule that I always thought applied.
Yeah.
But Sibley gives an out when it's manifestly, manifestly or palpably erroneous. And so my question is this error, does the trial court or the appeals court's error in the prior panel decision, was it manifestly or palpably erroneous? And if so, how do we determine that?
This court committed no error. This court rarely commits error. I know I go to the Supreme Court a lot saying that you do, but you don't do it very often, which, based on my track record, you can see that that's probably true.
You're on a win streak.
Well, sometimes, then the roof falls in on me for several months, and I despair and moan and groan. But no, you got it right. There weren't the facts there to tell you what fees were incurred. Now, if the court had meant to say, tell us what your estimate is and explain it a little better, you made a mistake. But I think you got it, you nailed it. You wanted a recalculation of damages of the incurred fees, and the trial judge didn't do it. He came up with a way to relabel and explain what he did, but it's not the incurred fees.
How do we know that?
Well, there was no evidence presented.
Well, neither party wanted an evidentiary hearing on remand. Where are we supposed to get this information? Where was Judge Broadman supposed to get it?
That's the question I've been dreading, but thank you for asking it before my time ran out. I don't know. I think the parties were confused about what was going on, and they should have focused in more on what this court had said. The trial judge kept edging into it. Well, maybe I should do something. Maybe you should get evidence and have more records. Maybe I should do that. And the parties were whiffling and waffling about that. All I can say is that...
They didn't really waffle. No one ever said, maybe you're right. They all said, no, we don't need a hearing.
Well, the language was a little bit less precise than that, possibly. But yeah, in the end, it sort of came out that way. But
they just wanted the case over with.
But
and I guess my concern about this is we instructed Judge Broadman, you didn't take out the fees for the North Spaces. Do that. Broadman looks at everything, hears some counsel, says, well, actually, I did that, and here's how I did that. The argument seems to be that whether he did that or not, he needed to have better records to support that that, finding, and that seems odd. It's not that the Baldwin was necessarily wrong, but that he didn't show his work well enough.
Well,
And building on Judge Howe's point, I would find your argument a lot more compelling if your client had demanded a hearing, said we can put on additional evidence to show that you haven't deducted these amounts, and they didn't do that.
I'd find it brilliantly compelling if that's what happened.
Yeah.
But, it's like the old story of the Pharaohs and the Israelites. When Pharaoh wanted to make things bad for the Israelites, he said, make more bricks, and I'm not even going to give you the straw to make the bricks. Have a nice day. And here, what we've got is the judge can't make the bricks because nobody gave him the straw. He doesn't have the raw material to do an analysis that is a recalculation of the incurred fees. And the parties were not good on this, I admit that, but don't you reach a point, though, the judge kept edging into this and kept implying that he needed facts, he needed the records, he needed something. Don't you come to the point where the adult in the room really has to say, okay, you guys are whiffling all over the place. I want you to provide me with the records that show the breakout, either the original records, if you got them, or reconstructed records. Doesn't it ultimately fall to the judge to be the adult in the room?
The adult in the room. As far as being the adult in the room, the judge ruled on what he was given. He doesn't control the evidence. What is presented by the lawyers. The objections that took place below and the objection, there was none. Your client was responsible for maintaining some of those records during the underlying litigation as the head of the association, was he not?
Not for this sort of presentation. They had this was the fees that they're asking for. They had the duty to make sure that they had the records.
I understand. Your client was the head of the association during a portion of the litigation. Do you agree?
Yes, Your Honor.
And probably had access to the actual billing records.
That's probably, Your Honor.
He didn't offer any of them.
But at the time this came down, he didn't have them. They had their records. They presented their records.
He didn't ask for them. He didn't ask for them to be disclosed. He didn't,
They disclosed them.
Okay.
What they had.
We have a remand from the Court of Appeals.
Right.
It's your second bite at this apple. You want a reduction? You want a something?
Yes.
You don't want an evidentiary hearing? You don't want to present oral argument? You don't want to, what exactly are you wanting to do down there?
Well, they had an oral argument.
Right,
as far as the grist for the mill, they had the grist. They had already produced the records. What they didn't produce was a breakout. The records were there, and they admitted in court, we did not give you a breakout of what they had provided. That's what we're talking about, what they had provided. Now, their duty then on the remand was to provide that breakout, either to say, oh, we've gone back to our original records, here's the raw records we have, and it shows this was for Northern, this was for Southern. Or, we're going to reconstruct the records. This is what we had for Northern, this is what we had for Southern, based upon a reconstruction. They didn't do either one of those things.
If it was a request for attorney's fees, there are statutes, there are rules, there are all kinds of ways you do that. Agreed?
Yes, Your Honor.
This is a different beast, though.
It's a very similar beast. It's still a horse.
It walks like a duck, it quacks like a duck, it may be a duck, but this is not a duck.
It may be an Appaloosa, may not be a quarter horse,
All
but
right.
this is a horse.
But we're talking about damages, which traditionally are not as exactly determined as an attorney's fees request would be.
You're 100% right with a great big but, and the but is the damages are attorney's fees. So we've gone around full circle again to try to say, well, how do you prove attorney's fees? You have records.
Well, as I understand the record, Baldwin said, give me the records. Nobody wanted to have the records. Nobody wanted to have an evidential hearing. So Baldwin did what he could do with the evidence that he had and the record that he had.
And that makes me want to weep because people were not focusing on the issue, although the trial judge was. He kept edging back to this over and over. He said, what about evidentiary hearing? What about records? More information, more facts? And in the end, it just sort of stumbled along into this analysis.
Well, if the parties aren't going to give the fact finder what the fact finder believes needs to be given, what's it to do? I know the argument is, well, there's no diamond case, but that doesn't seem right. The judge looked at the record that he had, and he mathematically determined to your client's benefit.
Maybe yes, maybe no. We don't know. I mean, we turned the original discussion. We don't know if it's more or less or the exact figure to the penny. We simply don't know because nobody bothered to reconstruct the records or nobody provided to provide original records that would have a breakdown. And of course they say, we didn't ever do a breakdown. So I don't know where we are on this other than I'm doing the best I can with what I got.
Thank you, counsel.
Thank you, Arn.
Thank
I'll
you.
reserve my 4 seconds.
All right. We'll keep that in mind.
Yes, sir.
Counsel, please proceed.
Thank you, Your Honors. May it please the Court, my name is Grant Watercutty. I represent the Biltmore Association. I had a lead-in prepared, but I think I'm just going to start by saying this. The issue that everyone seems to agree upon, both at the trial court level and the appellate court level, is that the fees, as they relate to the northern spaces, need to be deducted from the ultimate damages award. And on remand, that was the issue that was posed to Judge Broadman. And, Your Honors, Judge Broadman complied with this court's desire, but it's an interesting situation where he complied with that desire prior to this court's actual remand. Unfortunately, it wasn't explained very well by the attorneys, and I include myself in that. And unfortunately, it wasn't explained, at least not to this court's satisfaction, in Judge Broadman's original order.
Let me, and I obviously should probably let you go on, but I'm never. I was on the prior panel, as I mentioned earlier.
I remember.
In paragraph 33, we said, your opponent argues that you failed, the trial court failed to deduct the association's legal fees from the North Spaces litigation. We agree. So that seems to me, we've got law of the case now that it has not been done. Wouldn't you agree with that?
I would not agree with that, Your Honor. And the reason I would not agree is specifically stated in Judge Broadman's subsequent ruling, which occurred in April of 2021, where he explained that that deduction was made, and this is the basis that he used in order to calculate it.
I'm just talking about our ruling in the Court of Appeals decision was that it had not been done.
Okay. I agree that's in your decision.
Okay. And general law of the case principles say when an appellate court decides something, you have two remedies, right? Which is either you appeal to the people upstairs to tell us we're wrong, or you could seek reconsideration or clarification. And you did none of those three things, did you?
We did not, Your Honor.
And maybe this is a little bit outside the record. Why didn't you ask for clarification or reconsideration of that ruling? I mean, if it's so wrong, why didn't someone come and say, hey, Court of Appeals, what you should have said was it's not clear whether he deducted those from the award of damages. But that didn't happen.
It did not. And to the extent that I should have taken that step, perhaps I should have.
But as a general principle, when we decide something, if you haven't either had us correct it or asked the people upstairs to correct it, that's the law of the case. And so we're left with that Sidley case we asked you guys to look at, saying that trial court has to follow that unless it's manifestly or palpably erroneous. So is this the situation we're in now, that our ruling in the previous opinion was manifestly and palpably erroneous?
I would always hesitate to argue to the court directly that anything that they did was manifestly or palpably erroneous. But under the circumstances of this case, given what I believe Judge Broadman's intent was at the time of the original ruling and what I believe the intent of this court was in issuing its mandate, the end result, even though it was not necessarily the intent, was manifestly or palpably erroneous because both Judge Broadman and this court believed one particular fact, and that is my client was not entitled to damages stemming from this 2013 lawsuit as it related to the fees incurred for the northern spaces. Both this court thought that and Judge Broadman thought that. And what Judge Broadman believed at the time he issued that initial ruling, regardless of how it was briefed by the attorneys or put forth in his order, is that he had made that deduction. And when it was sent back to him, he provided the basis or the rationale to both this court and the attorneys for the reasons he believed that deduction that both courts believed should have been made was actually conducted. And I'm sorry, Your Honor.
Is there any evidence in the record anywhere that could suggest that a higher number than the 350/312 that was assessed was spent on the North Faces litigation?
There's actually ample evidence in the record for that, Your Honor. And if you look at Judge Broadman's subsequent order, he discussed this probably in more detail.
No, maybe I didn't say it clearly.
Oh.
So the court said there was 2013 litigation was $350,000 approximately, right? The fees for that.
The fees as they relate to the northern spaces, that was the maximum allowed amount that he said should be deducted for that purpose.
I thought that the court had said that the entire amount, CMN, reading from his ruling below, CIM estimated the cost of the litigation to be around $350,000 for both the north and south spaces.
That was the original estimate or budget provided by CIM for purpose of engaging in that lawsuit.
And then the assessment actually was about $312,000.
I believe it was $365,000, but that came at a later point. And it was after that assessment that the costs in the 2013 lawsuit began to spiral out of control, up to the ultimate amount that was spent in that case, which was $1,049,000. And that amount was introduced through our expert, Dwight Duncan, who it was not objected to, it was admitted, it was found as a fact that the full amount spent by the association on the 2013 lawsuit was over $1 million. And so Judge Broadman took that $350,000, which was the original estimate, and said this is the maximum amount that could have ever related to the northern spaces, not merely because of that estimate, but also because in October of 2014, after the northern spaces portion of that lawsuit was dismissed, the hotel, who was the defendant as to the northern spaces, submitted an attorney's fees bill that was granted for $136,000. That was the full amount that the defendant on the northern spaces portion of the 2013 lawsuit spent, and that amount was granted by the court. Now, at that time, the full amount of the association's attorney's fees was $470,000, and that is also in the record, and it was a finding of fact by Judge Broadman. And in the record itself, there's an email exchange between Mr. Finney and Rich Barr, who is the current president of the association, where Mr. Barr complained about how much had been spent. And Mr. Finney himself admitted of that $470,000 that has already been spent, a large portion of that went to the southern spaces, not merely the northern spaces. So that $350,000 was correctly found by Judge Broadman to be the maximum amount possible that could have been attributed to the northern spaces portion of the damages award.
Was it clear in an earlier litigation that the fees for the northern spaces should not be included?
Well, and that's a very valid and interesting point. It was our contention at the time of the trial that all of the fees for the 2013 lawsuit should be awarded to the association as damages. It was likewise Mr. Finney's argument that none of the fees from the 2013 lawsuit should be awarded as damages. And so the parties in the lawsuit did not make the distinction that later became critical of which fees were spent to what, because it was the intent of both parties to either ask for all or nothing at the trial court level. And in fact, Judge Broadman addressed that. It's in the independent record 221, I think it's page 4, and he said it's not surprising that the parties didn't make those arguments or draw that distinction at the trial court level, given the position that each party had taken. But bringing it back full circle.
Well, sure. But if the parties didn't make that distinction, they didn't argue that, then how or why would Judge Broadman make that decision, albeit implicitly, in its first ruling that I appealed here?
I can't speak to the subjective mindset of Judge Brodman, but my understanding, based on his ruling and based on some of the comments he made at the trial court level, was that he believed the association had willingly engaged in the 2013 lawsuit insofar as it related to the portion of that suit for the northern spaces. And there were certain emails and verbal communications and testimony at the trial court level that allowed or caused Judge Brodman to make that particular finding. However, he found that it was a breach of fiduciary duty by Mr. Finney to induce the association into engaging into that portion of that 2013 lawsuit related to the southern spaces that ultimately led to the association's damages. And so that's where the distinction was, as I understand Judge Brodman's thinking.
So counsel, on remand, why did you not present more evidence? Mr. Abney says, show me the bills, but why, you submitted it, you had oral argument, there was no new evidence, your client stood to lose an additional $350,000 in that damage award. Why didn't you bolster your argument with evidence?
Bluntly, Your Honor, and this has nothing to do with the legal issues on appeal, my client simply wanted this lawsuit done and has no anticipation of ever getting paid. We were still the prevailing party either way. This matter theoretically, hopefully, would have resolved at that point. We did not cross appeal when the original appeal was made in this case. We've not taken further steps because my client simply wants this gone. We believe that Judge Brodman had adequate information at the time to make a ruling in compliance with the Court of Appeals mandate, and that is why we presented only what we did.
Thank you for your candor.
Let me go back then. Despite your hesitation to tell me I was manifestly or palpably wrong, is that your position in essence, that either what he did was in compliance with the mandate, or if it wasn't, then we were wrong before?
That is my position, Your Honor. I believe that Judge Brodman complied with the mandate by explaining his prior order and showing how he believed he deducted the cost related to the northern spaces. I believe that's in compliance with the spirit of the court's mandate. If the court is inclined to disagree, then I would have to argue that the mandate itself was palpably erroneous, because what this court said is that based on the findings of fact at the trial court level, which this court did not disturb, that Mr. Finney is only required to pay damages as it relates to the southern spaces portion of that litigation. And what Judge Brodman did is he...
Well, that was Judge Brodman's ruling, is that he only had to pay for the southern spaces.
Correct, okay. But that was not disturbed at this court's level. And what Judge Brodman did is he said, I agree, that's what I meant to say originally, this is how I got to that number. Neither this court nor Judge Brodman has ever said as a matter of fact or as a matter of justice or as a matter of the evidence that my client is not entitled to the damages for the attorney's fees spent on the southern spaces portion of that litigation. Everyone agrees they are entitled to it. The only question is, what is that amount? Judge Brodman issued a finding of fact saying the most that should ever be deducted is $350. Giving Mr. Finney the benefit of the doubt, that is what I am going to deduct, the most that he is possibly entitled to. And bluntly, Your Honors, that is a fair result for Mr. Finney as he's going to get. I could talk for another 10 minutes. I'm happy to answer any questions that you have.
Let me ask just one kind of follow-up, because I have reached the conclusion that it had violated the mandate, and that the mandate, or at least our finding on that, was probably wrong. I tend to agree with Judge Brodman that if you look at it, that he had accounted for it. So how do we distinguish as a court wrong from manifestly wrong or palpably wrong? Or is all wrong just rise to that level? Because it does seem to me there needs to be some rein upon the trial courts in thinking that they can correct our errors, so to speak, versus following our wrong rulings. So how do we draw that distinction?
I think, Your Honor, I would refer you to some of the specific language of the Sibley case where it says, and I'm probably misquoting this, but adhering rigidly to that principle. essentially defeats the purpose of the court when it creates a wrong that exists. I'm definitely misquoting that. But Sibley essentially, if they didn't say this exactly, is attempting to say that the purpose of the courts are to seek justice. And if the prior decision is incorrect or if it's unjust, then the court is not bound by its prior decision. And again, drawing back to the end result of what both this court wanted and what Judge Broadman intended is the same. And under those circumstances, under Sibley, I don't think this court has any issue or problem rendering a decision that results in what everyone seems to agree is what should have occurred.
Everyone except for Mr. Abney.
Well, excuse me, except for Mr. Finney and Mr. Abney, correct.
Thank you.
Any further action on remand would be unjust then?
Well, I think to the extent that we reopen this case and continue this litigation for another year, given what my client has gone through to try and put this behind them, again, not necessarily the legal standard you're looking at, but yeah, I do not believe that would be just at this point. The decision is there. There is the judgment issued by Judge Broadman. I think it is appropriate. I think it is consistent with what this court wanted, and we would ask that that be upheld.
Let me ask you this before you stop. Let's say we say that the lower court did not comply on remand, and we need to send it back and have Judge Broadman is now retired, another judge reassess. Is there any circumstance in where Mr. Abney and his client can do better than the $350,000 Judge Broadman already said he accounted for in your estimation of the math?
Respectfully, no, Your Honor. We had, at the time of trial, about 5 banker's boxes full of records from CIM describing in explicit detail all of the fees that led to the $1,049,000. Those were not submitted. In fact, if you look at the record, I believe they were not submitted. They were offered. Judge Broadman said that he did not need them. To ask both my client and Mr. Finney to go back to the trial court level and argue over which specific line item in those 5 banker's boxes full of bills for litigation that span 4 or 5 years relate to northern spaces versus southern spaces, specifically when we already have the cutoff of the southern spaces, which is October of 2014, I think would be manifestly unjust to both my client and to Mr. Finney. And there is no evidence whatsoever, none has been pointed to by Mr. Finney, none has been argued by his lawyers to say that that amount that could be deducted from the ultimate damages is ever going to be less than $350,000. That is the absolute benefit of the doubt that Judge Broadman gave them based upon the notion that my client had the burden of proof, and there's no evidence to suggest it could ever be greater.
Any other questions?
Okay, thank you very much.
All right, Mr. Abney, it's your 4 seconds.
Judge Broadman wrote that the association had the burden of proof and did not provide the needed level of detail, page 5 of his order. Done.
Thank you, Mr. Abney.
Yes, Your Honor.
Thank you both for your arguments today. We will take them under advisement. We will issue a written ruling in due course. We are now at recess.